Hi, everyone. Thanks for joining. We're just going to give it a couple more minutes to let people trickle in.
Okay, it's about 12:03 now, so we're going to just get started. Good afternoon. My name is Maria Caruba Fuentes, and I'm here with my colleague Ellen Cheek. We are both senior staff attorneys at Bay Area Legal Services with quite a few years of practice between us. So many we probably don't want to admit to it. Just a housekeeping rule, we're going to reserve questions to the end of our presentation, and if you do have a question, please use the Q&A function on your panel in your toolbar. Also, I'll be telling you the CLE code number at the end of the presentation, and we'll also be putting it in the chat. So today our presentation is on exploring long-term care residents' rights, the theory and practice. Our presentation is going to focus on our experiences representing and advocating for residents in long-term care facilities and the challenges the setting presents. We hope you're here because you are considering working in this space. If you do undertake to represent a long-term care facility resident, you'll know about these rights both when they are being threatened, and you'll have knowledge of the rights that can help you in representing your client. So to start off, Florida statutes defines a long-term care facility in a variety of different ways in a variety of different facilities. It covers nursing homes, assisted living facilities, adult family care homes, board and care facilities, and residential adult care facilities. But our presentation will be focusing mostly on nursing homes and a little bit on assisted living facilities. And though the specifics differ, what is most important and what we want you to take away from this presentation is that the rights are intended to protect residents' dignity, autonomy in their long-term setting, in a long-term care setting, which we must remember is their home. We put together a chart to discuss the housing options and the spectrum for comparison of the protections or lack thereof in certain circumstances associated with the type of setting. The least regulated being independent living to the most regulated setting of a nursing home. In the case of independent living and nursing home settings, the level of regulation correlates to the vulnerability of the resident population. The rights and remedies in the assisted living space, however, are less clear and can be a topic for another day. Speaking of topics for another day, one of the features on our chart is the right to a hearing for an involuntary discharge or eviction in a skilled nursing facility. The nursing home discharge rights are so important that they're going to be treated in their own webinar that's going to be held next Wednesday, April 16th at noon. So we hope you tune in for that one as well. Because nursing homes and assisted living facilities are different types of congregate settings, they each have their own specific statutory provisions. In the nursing home setting, there is both a state statute and a federal regulation that detail residents' rights. While they're similar, they're not identical. Today, we'll focus on the statute, but if you represent a nursing home resident, always check both. So on this slide, I first have to clarify, the left panel states that it's rights common to all long-term care residents, but in actuality, the rights we've listed here are for long-term care residents in nursing homes and assisted living facilities. Some of the language, as I said, is extremely similar. Both statutory schemes have languages protecting the rights listed here on the screen. However, because nursing homes are healthcare facilities and most US nursing homes participate in Medicare and Medicaid, they are highly regulated by state and federal law. Additionally, in addition to the rights that we saw on the previous slide, because a nursing home is a healthcare facility, nursing home residents have additional rights relating to their medical care and treatment, which we've detailed here on this slide.
So, sounds good, doesn't it? The language is expansive and aspirational. Words like dignity and privacy and access and freedom appear frequently. As a practical matter, however, the transition from the statute to the facility can be a challenge. For example, consider the right to privacy in theory and in practice. So the right to privacy under Florida statute has several aspects. It specifies that the resident has the right to private and uncensored communication and access to a telephone. They have the right to send and receive unopened correspondence and the right to visit with those with whom they choose, with very limited exceptions. But how does this right to privacy look in the real world? Well, say you've been asked to consult with a nursing home resident. What to expect? If you've never been to a nursing home, imagine a standard 2-bedroom hospital room. There are private rooms in some nursing homes, but most of our clients, and particularly those whose stay is paid by Medicaid, must share a room. Let's say your client cannot easily leave the bed. This means you are going to be establishing the lawyer-client relationship at the bedside. What could possibly go wrong? Obviously, the situation is not ideal. For example, confidentiality is extremely difficult to maintain when the only room divider is a curtain. Nor is it easy to have a conversation with your client when their roommate's TV is on, usually at a stunning volume. What do you do to maintain your client's dignity and your professionalism under these circumstances? Well, if at all possible, you try to reach out in advance to the administration staff to arrange for a private room, at least for your initial consultation. I guess the important takeaway here is do not assume you'll have privacy. That's going to be by special arrangement in most cases. Another issue, many of our clients do not have a cell phone. Some have phones by their bedside provided by the facility, some do not. Often, the only option offered is the phone at the nurse's station. Again, less than ideal and maybe less than the statute contemplates. In a recent case, for example, our client was provided with a cordless phone at the nurse's station, but the range only permitted him to be steps away from the desk or the call was dropped. Yet another challenge presents when needing to exchange relevant documents or to correspond with your client. Most of our nursing home clients do not have computers or access to printers or fax machines. Often, the social workers will facilitate sending documents on the resident's behalf. But again, this arrangement is less than ideal when the facility is the opposing party. What to do? Again, help your client arrange for a private space with a phone for a telephone appointment. And really, whenever possible, go in person.
After much discussion, Ellen and I concluded that Privacy and dignity are often very interrelated concepts in the regulations and the statute. So we've listed several rights on this slide together. We'll discuss a few of the examples and the ones we've listed, and we'll provide some real life examples. The reality, the words in the statute are very clear and unambiguous, but sometimes not so clear in real life interpretation. For example, what does it mean to have your personal possessions in your living space mean? Again, remember the visual that Ellen offered, that space limitations are very limited, so your bedroom and living room are slightly larger than the width of a hospital bed. As an example, we represented one client whose pleasure and, in his opinion, therapy consisted of drawing on the styrofoam cups he received water in each day. He was proud of his work and had a few stacks of cups on his nightstand and table tray. This client was primarily confined to his bed, so his tray table had become his command center. So everything he needed either was on the tray table or within arm's reach of his bed because of his limited range of motion. The staff took issue with the fact that he had this stack of cups and often wanted to toss the cups. Although this is not the issue we represented him for, it is indicative of how difficult it can be to maintain dignity and a sense of home in a congregate environment. Something that seems so inconsequential resulted in considerable escalation of the tension between the resident and the staff and added to the circumstances which culminated in his discharge notice. I am pleased to report that after a fair hearing, we were successful in defending the client and the discharge notice was dismissed for other reasons. Again, that's going to be the topic of conversation for next week's CLE, and hopefully you can attend that. Another example that we have from the list that we previously saw, the two rights that relate to the control of medical treatment, the right to refuse medication or treatment, and the right to be free from the use of chemical restraints. And chemical restraints are not like physical restraints, which are intended to restrain in a physical way. Chemical restraints are often psychotropic medications, which are intended to keep a patient calm, have them be way more relaxed than they appear to be. In a recent case that we took to a fair hearing, the client frequently reported problems with care at the facility. When the issues were not addressed, he became extremely frustrated and he was very vocal with the staff. The way the facility dealt with his outbursts was to offer the client psychotropic medication rather than to address the efficiencies, which, interestingly enough, persisted, and the facility was eventually cited by regulators. But our client refused to take the medication, which is his right to do, because it made him feel disoriented and lacking the ability to even get out of bed. And again, rather than address the deficiencies, the facility served him with a discharge notice. He prevailed at the fair hearing, and interestingly enough, the administrator is no longer at the facility. The next right that we're going to discuss involves the general concept of dignity in care and privacy in care, treatment, and their living space. Families often request that they place what are known as granny cams in the residents' rooms to monitor care and deter abuse, which is certainly a worthy goal. However, query if this is consistent with the right to privacy in care and treatment and basic dignity in your living space. Just food for thought. Additionally, that same client we talked about with the cups in respect to dignity of care, he presented a challenge for the nursing staff that the care providers were not trained in maintaining. That individual, not to be vulgar or to disclose anything that is just part of what the case was, he was an uncircumcised male. And the nursing staff who worked with him felt that his comments were being sexualized, when rather none of the staff was well trained in how to maintain hygiene for a resident who was an uncircumcised male, which can result in serious health consequences such as UTIs, which are often a challenge for people living in congregate settings and create altered behaviors, which results in, again, tensions between the staff and the resident, and often is some of the reason why we get called in to represent individuals. Additional rights that are protected in both the assisted living setting and is mostly in the nursing home setting are pertain to civil rights and religious liberties. We're going to focus on these rights and what access to the long-term care ombudsman, as well as advocates such as Ellen and myself, mean to long-term care residents. Oh, I'm sorry, I jumped before Ellen. So sadly, many of our residents in long-term care facilities don't have family or friends to advocate on their behalf. If one of the residents' critical rights is being violated, many of the residents don't even have the ability to advocate for themselves. And it begs the question, if a tree falls in a forest and no one is around to hear it, does it even make a sound? This is where the long-term care ombudsman comes in. And if you're not familiar with that title, it is a role that is usually performed by volunteers, and the role itself is defined in Florida statutes, Chapter 400, Part 1. Long-term care ombudsmen are provided with broad authority under this chapter of the Florida statutes to visit with residents. They're permitted to review records. They are required to report violations. And more importantly, for this presentation, they can help a resident who wants to access counsel.
So we've given you a broad overview of the personal rights of a long-term care resident. And in fact, since we might have a little extra time, we can go back and look at some of the specific rights on particular slides. But we've given you a broad overview of the personal rights of a long-term care resident. If a resident has appointed an agent under a durable power of attorney, or the court has appointed a guardian, does that change anything? We often hear, for example, that a facility will defer to an agent or a guardian on all matters affecting the resident. Agents with a DPOA will mandate that the staff bar visitors or block callers, as an example. Is that okay? Well, the good legal answer is, it depends. We prepared a very simple chart, which definitely merits its own session, but we prepared a very simple chart to so we could discuss the idea that very few powers of attorney authorize control over a resident's personal life, and each guardianship must be reviewed for its specific authority. So, and we note that there's different types of guardianship. So a plenary guardianship is what's known as a full guardianship, means a guardianship of both the person and the property. Those are the most extensive guardianships, and the court orders which issue in those guardianships are usually pretty broad. A limited guardianship can be just of the person, just of the property, or one which does not remove all of the allegedly incapacitated person's rights. In those cases, you've really got to look at what the letters of guardianship say for the specifics of what that guardian is permitted to control for the ward. An agent with a durable power of attorney, yes, they're almost exclusively, as all of you likely know, almost exclusively for financial, the focus is on financial and related contractual matters, almost always. I've not seen one that determines, authorizes an agent to elect the particular residence, beyond possibly contracting for the residence, but controlling visitors. I don't believe I've seen a durable power of attorney that provides that authority, or limiting communication, for example. I've not seen that either. The point is, an agent with a durable power of attorney, in our experience, very rarely has the authority to control a long-term care resident's rights to the extent they often do, in our experience.
And just to interject with respect to durable powers of attorney, our experience has been that facility staff are not lawyers. They're not trained to understand what these documents really are designed to do, or the effect of them, and that just by virtue of having a durable power of attorney, that does not mean that the principal's rights are removed. That only happens, as we know, when the most extreme form is when a guardianship has been obtained and the court has removed the right to make decisions. In a durable power of attorney setting, the agent is supposed to act in the stead of the principal, not to the exclusion. In limited circumstances, of course, there's always going to be where the client has really lost capacity. The correct procedure then should be a guardianship if the person has even waxing and waning capabilities to be able to express what it is that they want, their personal decision making in their living setting, who they want to meet with, and certain things that they still can direct. So that's been a challenge that we've faced in the situations that we have become involved in.
But the one big takeaway for today is, even in the context of a guardianship, I would say even in the context of a plenary guardianship, which means over the person and the property, the most extensive guardianship under Florida Chapter 744, even a person who has been determined incapacitated retains certain rights. And this is really, really the important takeaway. And the retained rights include some things that might be basic, but are really, really significant in this context. Even an incapacitated person, even someone who is a ward in a plenary guardianship has the right to be treated humanely with dignity and respect, and to be protected against abuse, neglect, and exploitation. Really importantly, a ward has the right to remain as independent as possible, including having his or her preference as to place and standard of living honored. Next slide, Maria. For us, critical, and a ward has the right to access the courts independent of the guardian. This is such an important right for someone who wants to challenge either the guardian or the guardianship. This is a right that's retained by all wards. And very related and equally significant, a ward has the right to counsel, again, independent of the guardian, to receive prudent financial management. That's another, very important right for a ward, but not the focus of our presentation today. But The ward has the right to receive visitors, including potential counsel, and to communicate with others, like legal aid. And the ward has the right to privacy. So wards in guardianship may face the most challenges in asserting rights under Chapter 744, that was the guardianship statute, or under Chapter 400, which is the long-term care residence rights statute. If the guardian is resistant for whatever reason, this is when a long-term care ombudsman can play a really critical role in assisting a resident who wishes to assert their rights. Some real-life examples. In one case we handled, an agent with a durable power of attorney convinced the nursing home staff that his mother could not rehabilitate enough to go home. That might have been because he was living in her home, but I digress. He convinced the staff that his mother could not possibly rehabilitate enough to go home and agreed to the plan of care that involved the heavy use of psychotropic drugs. Despite her often groggy condition, miraculously, she found her way to us. Once we accompanied her to a care plan meeting without her agent and communicated her desire to stop psychotropic medications and begin physical therapy once again, she made such progress in her therapy that she was cleared to go home within a few months, which was her wish all along.
And just again, to interject here with that particular client, my first interaction with her at the facility, her speech was so slurred from all the medication that she was on. I inquired if she had suffered a stroke, and she told me that she hadn't. And then once I was able to look at the records, there was nothing that had happened to her that would result in her having this slurred speech pattern. And once she made the determination to say that she was no longer going to take the psychotropic medication, every single phone call to her, I couldn't get over the change in her voice, in her ability just to enunciate her words and to be clear in what she was communicating to me. So the use of psychotropic drugs can really stand in the way of the care provided. Now, typically what ends up happening, I mean, they can't just give psychotropic medications. There has to be an order for this and some basis for it. But what's interesting is that in a lot of nursing home cases, when Ellen and I spend a tremendous amount of time examining medical files when we're trying to go to hearings or prepare for pushback from the facility or just to know what's going on with a resident. We often see people in long-term care facilities diagnosed with mental health disorders that typically manifest themselves in very younger individuals. That's not to say that there aren't cases where these things get diagnosed later on in life, but it's interesting that so many nursing home residents get these diagnoses where the course of treatment are psychotropic medications. And we do fairly regularly surmise that the use of these drugs are for the purposes of keeping the residents calm, for keeping them not asking for so many services, because care is limited because there's only so much staffing at nursing homes. And there are a lot of people who need assistance with a lot of their activities of daily living. So the staff is doing the best they can, but it's so much easier to have a patient who doesn't keep ringing their bell for assistance or, is sleeping through whatever needs they might have because they're so sedated by the use of these psychotropic medications. And from the moment I met this client, even with her very slurred speech and even with her very slow movements, she was very adamant that she wanted to go home. And right from the beginning, it became clear to me that it was the agent that was controlling the the plan of care. And like Ellen said, it wasn't unrelated to the fact that he had taken up residence in her home. And for him, that was going to be the long-term plan. He even confronted me at the facility, asking for my card, telling me I was going to hear from his attorney. And I of course, gave my card and said, I'll welcome a conversation. I'm here to advocate for the resident, and that should be your role as well as the agent. But I never heard from anyone after that. And it was so gratifying to me when my client was finally able to go home.
I just wanted to say too, I saw it out of the corner of my eye that Nicole put in the chat, and a really important study that I think what I saw was that it's the one which it was a federal study commissioned a while back, which documents the abuse of psychotropic drugs in the long-term care context. And it's very important to be familiar with the use and abuse of these drugs, because again, if the resident was compromised in her ability to advocate for herself before psychotropic administration of psychotropic drugs, she's certainly not going to be able to effectively advocate for herself if she's being medicated in this way inappropriately.
Also, again, just to go back to one of the points we were talking about with when we're dealing with guardians, the other thing that we've found out is in the cases that we've been involved in, even where there's a plenary guardianship put into place, for whatever reason, almost all of the wards that we have examined their guardianship, the letters of guardianship, removing the rights, they almost all retain their right to vote. And another responsibility of the staff at a nursing home is that, and as well for assisted living facility residents, is that they're supposed to help effectuate the residents' needs and effectuating the rights that are protected. So in a situation where that person retains the right to vote, it's very important that the facility or an advocate act in a way or aid that resident in obtaining the ability to vote, because most people in long-term care settings can't just go get an Uber and go to their voting place, or oftentimes they've been moved to a place where they are not registered to vote. We actually had that specific example. And then
Yes,
early on, when we first started in this space, we went out to do a presentation to the long-term care ombudsman group in our local region and telling them about a project that Ellen and I were working on, which is how we started working in these cases. And this one long-term care ombudsman was so offended by a facility that their response to a residence, a person who was a ward in a guardianship, their request to actually exercise their right to vote was they did like a mock voting thing where they pretended as if they were casting their votes and that their votes were going to eventually be delivered to the appropriate polling place. And it's just clearly not the intent of the statute and the protections that the legislature has thought about very thoroughly. and detailed in these sections, and then to have no one following through to make sure that these rights are actually able to be exercised. So that is where, again, advocacy plays a really huge role in affecting the lives of people who live in long-term care facilities. And we started off our presentation talking about this, but no one decides in their life that in their golden years, they're going to live in a space that's the size of a hospital room, sleeping next to someone they don't know, who they have no connection to, that has different sleep patterns, that watches different television shows. So that in and of itself is an assault for an individual who, while maybe not mentally incapacitated, only physically incapacitated, they find themselves in this type of a setting where an outside observer may lose sight of the fact that this is their home. That is why the resident with the cups on his table it was important to us to communicate that there was a reason why he was keeping the cups, that the person who wanted to vote, there was a fundamental reason why they were articulating the need to have someone stand up for them and advocate that this was important to the facility as well.
Exactly. Um, we can't really say enough about how important the state long-term care ombudsman program is here. Again, some people are fortunate. They have family, they have friends, they have a network. They can communicate easily with the outside world, if you will. They may even have laptops and smartphones and all those neat devices. But in all of the cases we have handled to date, that has not been the case. The people who have become our clients did not have a natural support network, and they certainly didn't have access to computers or smartphones. So a long-term care ombudsman, who again has the right to go to a facility actually at any hour of the day or night, who can visit with whomever, residents, with staff. It's all provided, and it's all designed to provide an independent advocate and link for a resident in a long-term care facility. So I want to give you a really moving example, I think, in another very compelling case. A long-term care ombudsman helped a resident who is currently a ward in a plenary guardianship connect with us. Well, limited, she has the right to vote. A ward in a guardianship connect with us because she wanted to address issues with her guardians. The long-term care ombudsman went above and beyond. We arranged for her to provide, we made an appointment with the ombudsman at a time she could go be with the resident in the facility and lend her cell phone so that the resident could have the initial conversation with our office over the phone in the privacy of her own room. And that is exactly what happened. The initial intake was over the phone in her room where in her single room. Before that time, the guardians had not allowed her to have a personal cell phone, and they had also required that any calls she did make had to be made from the nurse's station with a staff member present. Also, all those calls were reported by staff to the guardians. Those same guardians attempted to block our access to the facility and the resident. And I want to bring up one point about the long-term care ombudsman program. So we've told you and many of you may be familiar with the heroic volunteers in the field, but also the ombudsman statute provides for what's called a legal advocate, which is essentially a general counsel for the ombudsman's program. And when we were initially not allowed to access our client by the facility because they had contacted the guardian and the guardian said no. We left our cards, we left a copy of the statute providing the right of a ward to access counsel, all kinds of good materials, and we left. But we also reported to the legal advocate for the state long-term care ombudsman project and believe that it is possible that intervention on that score help things along, because it is a resident's right. And the ombudsman program, it's a mouthful. The ombudsman program and its legal advocate is mandated by statute to do everything possible to give, to empower residents and to enforce those, to make those rights a reality. I will tell you, in the story I was telling you about, a very long story short, after 9 years of being silenced by lack of access to the outside world, by lack of any privacy whatsoever in her personal communications, this resident was finally given voice. Again, another really, for us, very, very gratifying outcome. And at this point, we did
just to interject, Ellen, just to reiterate the importance of the long-term care ombudsman, they often, before we get out to a facility, they often will provide us with some background documents that they're, again, able to access under the powers that are the very broad powers that are spelled out in Chapter 400. And they often act as a liaison for us just because we cover a fairly large geographic area. And it's not always feasible for us to get out to the facility to get a copy of something, or to ask a client to sign something for us if they can't do an electronic signature. And the ombudsmen are always willing to facilitate assisting us with those types of tasks. The other thing too that Ellen and I often do, not often, always, we always go out as a pair to meet with our client, especially our initial meeting, because oftentimes, especially when we're dealing with someone who has a durable power of an attorney and the agent is resistant, or there is a guardianship in effect, or just the average resident, we both want to engage with the resident and have an opinion as to their abilities to form an attorney-client relationship, because a lot of residents that are housed in long-term care facilities are on a spectrum of capabilities. And we use the rule, governing attorneys as to working with clients who are under a disability, and that guides a lot of the decisions we make as to how we proceed. And in the case with the guardian, we were very cautious. I mean, extremely cautious. We did a tremendous amount of research. There's not a lot of case law on there, but there are a lot of law review articles about the rights of wards and how to protect those, especially in situations where you're getting pushback from the guardians. And in that case that we're talking about, there was a tremendous amount of pushback from the guardians, and the long-term care ombudsman was crucial in helping us overcome the hurdle, and as well, like Ellen identified, the legal advocate. So working together with the long-term care ombudsman, Ellen and I have been able to effectively represent our clients, get the information that we need from our clients, and communicate effectively with them with this collaboration with the long-term care ombudsman. And but for this project that we had, we probably would have not had this relationship with them. And before we started on this program, interestingly enough, when we first got the grant 3 years ago, our first reaction was, I've never really had one of these cases before, but I can tell you in the 3 years since we've been working in this space, we have the amount of cases and the types of cases that we're seeing, we've seen an uptick. And there are very few situations that haven't merited our involvement. And sometimes it's as benign as, we had one resident who, because remember, people who go to live in long-term care facilities often leave behind the life they were living in the community. And we had one resident who had a home in the community. And again, she was at odds with her family. She didn't trust them for whatever reason. And the home was sitting there, and there was a reverse mortgage on it. And she needed advice and the ability to understand what her next steps were. So it isn't always a battle against the facility or a discharge case. It's everyday things like that, that residents of long-term care facilities still have to address outside in the community. We often will get called in, like we said, with the client who had the agent with the durable power of attorney who was impeding her recovery. Well, we at the direction of the client and the request of the client, we revoked that durable power of attorney. So there are many aspects in the lives of long-term care residents that advocates can step in to improve not only their living conditions, but also to avoid larger problems in situations that they still address out in the community. And
I was just gonna say one last point. The ombudsman only opens a case with the resident's explicit consent. So the ombudsman only reaches out to us when explicitly asked to do so by the long-term care resident.
so at this point, that's the end of our formal presentation, and we thought we would leave the last 10 minutes or so of the presentation to field any questions that you might have. I didn't advance the slides, but there's our question slide. And I'm going to try, I don't know if there's anything in the chat as far as questions go. Nicole, do you see anything? I don't see anything in the chat.
Yes, we have one question so far, but please feel free to add more. The question, it says, is about the right to refuse treatment, which you talked about a little bit about during your presentation. It says, how would you handle a case where someone has been deemed incompetent to provide informed consent, but still refuses certain treatments or medications? And goes on to ask, follow up, can a nursing home force a resident to undergo painful wound care treatments if he or she has been deemed incompetent? What about refusal of medications? Apparently this individual seeing this more and more.
Okay.
There's a lot. And that's a really excellent question and an excellent example of how complicated these apparently clear rights become in practice. And I would say, and I have to look back at the statute, but there are exceptions if compelling medical, in certain cases where the record clearly documents the need for certain measures. But I would have to look. That's a really that's an interesting situation.
What often happens in situations like that is that they'll use the Baker Act as a tool to take this to the next level, because now they've become a threat or a danger to themselves, because assuming that no one's willing to file a guardianship proceeding, they can often use the Baker Act proceeding. And I don't know the answer about forcing someone to submit to, you can't force, you could pills down someone's throat, but there has to be a mechanism, and I guess judicial intervention would need to be the next step.
Actually, the statute does provide us with some instructions. I just would want to think about a situation like that a little more carefully, but it says a resident has the right to refuse medication or treatment and be informed of the consequences. And be informed of the consequences. So if the consequences, and what I think that means is informed of the medical implications. What happens if you forego this treatment? What happens if you don't take this medicine? What are the consequences? And I think that's exactly what that means, but I'd be happy to discuss this further after reviewing some things.
Because they can't, the ability to give informed consent has now it's not available to this individual for whatever condition that they're suffering. So it takes out the second part of the statute. They have to be informed. They are being informed, but they don't understand the consequences. So I think that there would have to be a next step taken, whether that's
whether there's a healthcare surrogacy or healthcare
proxy
surrogate document or proxy in available, that kind of thing. I would just want to give it a little bit more thoughtful analysis, but that's an excellent example of when the rubber meets the road. It looks pat when you read it, not so much in real life.
Yeah, it's definitely a complex situation. And I think this individual kind of followed up in here, the Q&A, with the situations that they're seeing is when someone gets deemed incompetent, say in the first month of, I guess maybe they're of being a resident, but then they have periods of lucidity where they're, quote unquote normal. And it's in those moments that they're refusing the treatment.
Right. And just on the beat them with basics score, there's a huge difference between a facility physician saying someone's incompetent and a judicial declaration of incapacity under Chapter 744. Big difference, and with great legal implications. So, and there is such a thing as periods of lucidity. And I also think that the legal trends is to re-examine definitions of incompetency in some very specific circumstances and contexts, and this could perhaps be one of them.
We have one other question so far, actually two. We have, what is the normal way residents get to vote, if that's something that you're familiar with?
I don't think there's a normal way.
Yeah. So what you want to explain what we did, Ellen?
Well, in our case, again, if you have, I think there are just so many specific circumstances. If a person can go down to the administrator and say, I got an absentee ballot, could you, whatever, it depends on why the person is in that congregate care facility and whatever. But my understanding of the civil rights portion is that they're supposed to assist with that. So if a resident says, I need help, I want to vote, I think the staff should be assisting them. In our case, the resident had been moved from another county to this facility. And we were able to place a three-way call with her. Well, it wasn't three-way, we were sitting with her, but we were able to help her call the registrar of voters, who confirmed that her registration in the adjacent county was active, and that she could it could be reactivated over the phone. And a ballot was sent to her, I believe. Is that right?
Yes, that she got an absentee ballot by mail. The facility, she filled it out on her own, and the facility made sure that it was posted. And we intervened in making sure that the facility knew that this was important, and that we knew that the client had the ballot, and that we were requesting that they make sure that it got posted in the mail the way it was supposed to be
And
done.
that was important because this was a warden of guardianship, and heretofore, she was not receiving any personal mail. It was all being forwarded to the guardian.
And she was the one who expressed the interest in voting and actually voting, because in all of the years she had been in the guardianship, neither one of at any point did the guardian request an absentee ballot or follow up on that. And we felt that was another empowering thing for us to do on her behalf, and it was so simple to accomplish. It was simple, but it was advocacy. And again, she felt heard, because for 9 years, no one had listened to her request to want to vote.
And remember that in the orders of guardianship, her right to vote had been retained. It was one of the only rights that had not been removed. So she had the right to vote.
You said there was another question, Nicole?
Well, actually, it's not so much a question as I guess an observation, an example of something. This individual says that they had a case where Adult Protective Services stepped in to file a guardianship against their client because he was not taking his medication and they were claiming self-neglect. So no question, but something.
Topics for almost a whole other session. But we would welcome communication. We would welcome.
Yeah. So I'm going to advance the slide to our contact information, because a lot of this area is very gray, and it's so helpful to talk about these cases, to think about the scenarios, to real life experiences like this. And Ellen and I would welcome anyone who wants to inquire. If you have a case, we'd be more than willing to staff cases with you. And Nicole has done that for us as well in her role. It really does help talking about reviewing the statute, but also the facts, because the facts drive really the reality of the situation. So please reach out to us. It's so important to advocate for this very vulnerable population, and the statutes, like we said, are there and designed with the intent of preserving these rights. And we are often the only line of defense for people who find themselves living in congregate settings. So I promised you that I would give you the CLE number. We are almost at the end of the time. And if you have questions, again, email, reach out to us. But the CLE number is 250-2850, N as in Nancy. And we thank you for your time and your attention and your interest in this subject. And we strongly encourage you to come to the next week's presentation, where Nicole is the main act, and Ellen and I will just be consulting and giving, again, more real life examples on the topic that they're talking about, which is nursing home transfers and discharges. right, Nicole? That's the topic.
Yes,
Okay.
well, actually, Toby Edelman from the Center of Medicare Advocacy will be the main act. I'll be
Oh,
there.
okay.
Yeah, so maybe that'll entice people a little bit more. But yes, I included the registration link in the chat along with the reference number, the CLE reference number. It's also 1 credit of elder law certification. But thank you both so much. This has been a really informative and wonderful session, and I hope I'm sure all attendees learned a lot like I did. So thank you.
All right. Well, thank you so much for inviting us. And again, reach out to us, anyone who wants to discuss cases. Thank you so much.
Thank you.